course.
Thank you, Your Honor. This hearing is the matter of case number CFI 070-2018 before Justice Lord Angus Glennie. The hearing is being held by way of video conference in the DIFC courts in Dubai. Any orders or directions made during or after the course of this hearing will be issued by the registry on the judge's instructions. The claimant is represented by Tamimi and Company. Lead counsel is Mr. Sharif Shift QC. Third defendant is a litigant in person, represented by Mr. Hussein Al-Hashmi. Thank you.
Yes, thank you. Yes, Mr. Sharif.
Good morning, my lord. My lord, perhaps somewhat unusually, I might ask your lordship just to identify who's present at today's hearing, because I see, just looking at the Teams link, that in addition to Ms. Al-Hashmi, there is also Ms. Alanud Al-Maraki, who your lordship will recall attended the hearing on the 1st of March on behalf of the other defendants. So it might be helpful to clarify who is here today and the capacity in which they're purporting to appear.
Why does it matter?
Well, my lord, as I understand the position, having received a communication from the registry overnight, one of the issues today is Mr. Al-Hashmi's application for a stay. Now, your lordship will remember that Ms. Alanud made a very similar stay application before your lordship on the 1st of March. And one of the issues will be whether that decision should be revisited. It would be helpful to understand why Ms. Alanud is here and whether in particular she's purporting to represent the beneficial owners of the company, and if so, the authority that she has to.
Ms. Alanud, can you hear me?
Yes, Your Honor.
You, I think, on the last occasion, you represented certain of the defendants in the case. Is that right?
Correct, Your Honor. Correct. My sisters and my father, Mr. Ahmed Al-Maraki and Ms. Sharifa and Ms. Maryam Al-Maraki.
Yeah. So that's 6, 7, and 8.
Correct, Your Honor.
And you're attending today for what purpose?
Your Honor, Ms. Maryam Al-Maraki and Sharif Al-Maraki, along with Mr. Ahmed Al-Maraki, had opened a criminal case against the IDBI bank regarding the facility agreement documents.
Yeah.
And it was on the 22nd of Feb. However, it took 3 months until it reached until the by police sent yesterday an email to DIFC regarding regarding representing these documents, the original of these documents, that to Dubai police for investigating.
Is that the communication which? Sorry, I don't have I don't have that in front of me. Can you read out what that says?
Excuse me, Your Honor, I can't hear you.
Can you read to me what that communication says from the police?
The communication, actually, it is an between the police and the DIFC. I do not have a copy of it. However, I just have a copy or a number of the reference number of the case, Your Honor.
The case has a reference number.
The criminal case.
What is number. The reference? What is the reference number?
Sure, Your Honor. It's 222 00
yeah.
433.
Sorry, 433.
Correct. 4953.
I see. But you don't have anything more than the DIFC have received.
What is no, Your Honor? What is between the correspondent between the Dubai police and the DIFC? It is internally. I do not have any copy. And just to add something, Your Honor, this criminal case has opened because those facilities that has been provided from IDBI was signed by my father where he was out of the country. And that they
wait a minute, please. We're not going to go into the merits at the moment. We will
Sure.
come to that later.
Okay.
Can you give me a moment, please?
Sure, Your Honor.
All give me a moment. I just want to bring up on my screen what I know about the police communication. Okay. Mr. Sharif, should I hear from Mr. Al-Hashmi first to find out what his position is about this?
I think so. As I understand it, Mr. Al-Hashmi is making an application for a stay today, so it would be, I think, helpful to hear from him. Perhaps I could just, to assist your lordship, make a few preliminary points that your lordship may want to have on the agenda. But firstly, at the last hearing, your lordship said that Mr. Al-Hashmi would need to explain to the court, if he was unrepresented today, why that was. And we've explained that with extracting the relevant parts of the transcript in our skeleton. That's the first point. The second point is that Mr. Al-Hashmi hasn't complied with your lordship's directions for this hearing. We've had no communications with him.
Isn't this a bit premature? I mean, if Mr. Al-Hashmi is applying for the stay, shouldn't I hear that? Otherwise, these points may go to the merits of your application. I can't see that they affect the question of the stay.
Well, the first point, it's a matter of obviously for your lordship, but your lordship was quite clear with Mr. Al-Hashmi at the last hearing that he ought to be represented, and your lordship may want to understand why he isn't, and also your lordship may want to understand why this application has been sprung on us today without any forewarning at all.
I haven't heard the application yet, so I don't know what the application is even.
I'll leave those points with your lordship. I'm obviously content to hear Mr. Al-Hashmi.
Yes, Mr.
Okay, Your Honor, do you hear me?
Yes, I can. Thank you.
Yes. As I told you, the case is about I am appointed by Abu Dhabi court to run the company, and the company didn't have any fund or money to cover the legal cost or to hearing an advocate for the representative in this case. What I know from the company that this facility not directly related with the IDB bank, since the Delma engineering did not sign any document with the bank to get the facility.
Mm-hmm.
And
that goes to the issues between the parties, but I thought you had an application to make to stay the proceedings. Do you understand what I mean? I thought you had an application.
I understand. I don't know what means stay the proceedings.
Stay the proceedings means that the proceedings come to a halt while other things happen. Are you asking for these proceedings to stop for the moment Well, and for what purpose? Sorry, I'm not explaining it very well. I don't know whether the court staff can. Would you be happier to understand that in Arabic?
Yes, it's better.
If you wait a moment, I'll ask the court staff if they can. Who is there? Is that Maita? No.
It's me, Your Honor. This is Shahla.
Shahla, would you be able to explain to Mr. Al-Hashmi in Arabic what staying the proceedings means?
Yes, Your Honor. Just 1 second. I need instructions from the registrar.
Okay, sure.
I'll have her join immediately, okay?
Well, maybe the registrar can explain it, maybe more sure.
Yes, I will get her to join the call immediately.
Thank you.
My Lord, if I may just interject while we're waiting, just to use the time productively, the communication that the registry has received from the Dubai police wasn't copied to my clients, and we have asked the registry for a copy of it, but the message we got back was that it wasn't going to be shared with us for policy reasons. Now, obviously, that's a matter for your lordship.
I'm told that requirement or a prohibition on copying a police message to someone else.
I see. I mean, your lordship, no doubt, will be anxious to ensure that the position is fair as regards my client. I think we have the gist of the contents of the communication from the registry's message, and that may be important because, as we understand, the gist of the message is that there is a criminal investigation, not a criminal action. There's been no indictment, no criminal proceedings.
Sorry, stop. Are you saying that as a definite assertion, or are you saying you don't know whether there has been?
Well, we're not aware of any criminal proceedings.
It's important to be precise on this.
Yes, exactly, my lord. Exactly.
You seem to be making an assertion that there wasn't, and now you're saying.
So if I may, though, just to develop that point, because the point that I was making was carefully chosen. Our understanding, so we're not aware of any criminal action.
Yeah.
Our understanding from the message the gist of the message that's been communicated to us from the registry is that there is a criminal investigation.
Yes.
It's not suggested in those communications, as we understand it, that there is a criminal action. Now, your lordship has the advantage of the communication that I don't have, but that is a distinction that we understand can be made on the basis of that document, on the basis of what the registry has told us about that. And if that's right, that is a very important distinction for reasons I'll explain in due course.
I know the importance of the distinction. I don't know at the moment what the factual position is. So let's just wait before we say any more. Let us wait until the registrar comes on the call.
Good afternoon, Judge. It's Registrar Hanady here. How can I help?
Good afternoon. I think Mr. Al-Hashmi, I think wants to make an application to stay. No, I think he wants to make an application to stay the proceedings, but I'm not able to explain to him in words in a way that he understands in English what that means exactly, staying the proceedings. Would you be able to explain to him, are you allowed to explain to him in Arabic what staying the proceedings means?
Yes, well, strictly speaking, no, but I'll try my best just so we can obviously get the point across. أستاذ, stay يعني الكيس بيوقف على ما الانفستيجيشن مع دبي بوليس تخلص، ولما يطلعوا القرار يعني لما شرطة دبي تطلع القرار تاعت الانفستيجيشن الكيس بيرجع عند محاكم DIFC عند محاكم المركز، ونفتح الكيس من وقت ما اتسكر. يعني الكيس ما بتسكر بس بيوقف على ما الانفستيجيشن يكون concluded من ناحية دبي بوليس. مفهوم؟
ايوه. شو المطلوب مني طيب؟
المطلوب هلا القاضي حابب يعرف منك لازم يعمل الكيس لازم يتوقف هلا بده يسمع من الأطراف. الكيس
تمام.
يتوقف هلا حاليا من هون لتخلص الانفستيجيشن مع شرطة
تمام.
دبي، أو
تمام.
الكيس بمحاكم المركز تستمر كالعادة.
توقف نفس لا توقف لين ما يخلص التحقيق إن شاء الله.
أوكي، بس لازم هلا تفسر للقاضي ليش الكيس لازم توقف هلا، وبنسمع من الطرف الثاني، والقاضي بيطلع قراره بعد ما يعني بعد ما يسمع من الأطراف.
بس أخت نور، أنا ما عندي محامي يدافع عني عشان يشرح القاضي الجوانب الفنية والقانونية اللي تخدم وجهة نظري كحارس قضائي على شركة دلما.
هو صح ومفهوم هذا الحكي، بس
وطلبت
يعني
إن المساعدة، وما في الشركة ما فيها لا فلوس ولا عندها فند ولا عندها هذا.
هذا
شركة
مفهوم. يعني يعني القاضي بده يسمع منك كشخص كليتيجنت ان بيرسون، يعني يسمع منك من يعني in your words زي ما بيحكوا، يسمع.
أنا يمكن أشرح الشيء بالعربي، أنت تترجم لي القاضي بالإنجليزي ولا
هلا انا لا
لازم؟
ما فيني هيك اعمل، عشاني انا مركزي مثل القاضي، فانا ما فيني يعني ما بدنا يكون في situation انه انا ما عم بترجم كل كلمة على الصح او انسى
أوكي.
اترجم اي معلومة. فاضبط اشي تجرب يعني بالانجليزي باللغة الانجليزية، يعني تتكلم القاضي وتقول له ايش القصة وليش لازم الكيس يوقف هلا من هون للانفستيجيشن تخلص، والقاضي وقتها رح يعطيك جواب بعد ما يسمع كمان من المحامي من الطرف الثاني.
أوكي.
يعني بكلماتك أستاذ.
أوكي.
أوكي.
Okay.
مشكورة.
Okay. Your Honor, let me explain the situation of this company. Delma Engineering.
Wait one moment, please. Just one second.
Yes.
The Registrar Hanedi, could you stay on the call for a little bit, just in case we run into difficulties?
Absolutely,
Yes.
Judge. I'm on the call, and just for the record, I've just explained to Mr. Al-Hashmi, to the best of my ability, I've translated what a stay is, and I explained to him that essentially the case stops. It doesn't end, it doesn't conclude, it simply stops and remains at a standstill up until the police investigation is concluded. And I've explained to Mr. Al-Hashmi that he ought to, if he wants to have the case stayed, then he ought to explain that and express that to the court. Mr. Al-Hashmi said that he doesn't have legal representation. The money, there is no money in the company for them to be able to bring on legal representation, and it's for this reason that he can't explain the legal implications that a continuation of the proceedings would have on his company. So I said, please explain in your own words why you would like to have a stay in these proceedings. So provide the judge with your narrative on why there should be a stay if that's what you want. And obviously the judge will be hearing from Mr. Shivji from the claimant's perspective, and he'll hear submissions from both sides before he's in a position to make a decision on the point of a stay.
Thank you very much. So, Mr. Hashmi, are you making an application for a stay, or are you content to continue with the claimant's application against you?
With a stable procedure.
Sorry, can you say that again?
Why? Because tell you there's many facts. When I in charge or appointment by the court for this company, the company actually their work was stopped. There's no headquarter and there is no documents for this. And about the loan, they did not any document that the company representative or legal representative before I joined signed a loan for the loan. And we don't know about the purpose of this facility and where it's gone, because we didn't have any document or support document for this project or related to which project.
Mr. Hashmi,
Yes.
that is part of your defense to the action. But at the moment, I want to know whether you say that the action should be stayed, halted temporarily, or whether you are content to go ahead with the action and argue on the merits of the claim. Do you understand?
Okay. Okay. What I would like to hold the case until the criminal investigation finish. Why? Yeah.
Carry on.
Why? Because this they maybe they will found there's an legal document or fraud agreement represent in this case. So what I want to, Your Honor, to stop all execution against Delma engineering on me.
Right. Okay. Now, Mr. Shivji, do you? What I want to
Your
do
Honor,
is find.
this is Alan.
Yes, of course.
Yes, could I add something, please, Your Honor, regarding Delma Engineer? The IDBI has presented the facility agreement signed by my sister Miriam, whereas Delma Engineer is a partnership between Miriam and the other partner, Mr. Dhul Faqar. And the memorandum of agreement between Miriam and Dhul Faqar states that any financial documents should be signed, duly signed, and IDBI has presented singly signed document facility agreement from Delma Engineer.
Ms.
Yes,
Allen,
Your Honor. Yes, Your Honor.
that is an argument on the merits of the case, which is not what I'm concerned about at the moment.
Okay.
I'm concerned about today's application. And I'll come back to your role in it in due course. I want to hear what Mr.
Thank you, Your
Shivji says. But before I hear from Mr. Shivji, I just want to ask the registrar, Registrar Yanadi, can you hear me?
Yes, yes, I can, Justice Glennie.
We have, you provided me with a very rough translation of what we've received from the police, but it doesn't say whether or not there is a case being opened by the criminal authorities in Dubai, or whether the police are simply investigating in advance of deciding whether to open a criminal case. Are you able to help on that?
Absolutely, Judge, you're entirely correct. There is nothing on the face of the letter that suggests that a criminal case has been open with the Dubai courts. As far as we can see on the face of the letter, there is simply a police investigation ongoing.
Mr. Archie gave a reference number, a criminal case reference number. I don't know if you wrote it down, but it's 222-00433-4953. Do those numbers appear anywhere on the communication from the police?
I'm just going to have a look at it now, but typically a criminal case would bear I suppose a number that resembles a CFI case number with the year in which it was opened. So based on that number, given that it's simply a 7-digit number or so, it doesn't seem to me that that's a criminal case number. It seems to me that it's an investigation number. And Judge, if you wouldn't mind repeating the number that you've just read out for me, and I'll quickly check it. Yeah. Was it 222?
222.
Yes.
222-00-4334-953.
Yes, correct. So that does appear on the letter. And it's in Arabic, the literal translation or the exact word that appears is mu'amala, which is paperwork. That's a literal translation of mu'amala, which is similar to investigation. There is no reference to a criminal case based on my reading of the Dubai court letter. Sorry, of the Dubai police letter.
Right. Thank you very much.
You're most welcome.
Mr. Shivji, what do you want to say?
My Lord, I have 4 points. I'll summarise them first and then can take your lordship through the detail of them. The first is that under the provisions of UAE law that have been cited, the power to order a case management stay is contingent on there being concurrent criminal and civil proceedings. Now, as your lordship's just heard, there is no concurrent criminal proceeding here. There is simply an investigation. And so we say that that power to stay doesn't arise. That's the first point. The second point is that the relevant provisions of UAE law under the criminal code and the civil code don't apply in this court. They are essentially civil in nature, and I can develop this point. And as your lordship will know, this court has its own freestanding authority and its own rules on civil procedure. And in the creation of the DIFC courts, the UAE laws on civil and commercial obligations and procedures were excluded, so that this court has its own freestanding regime and is not bound by those particular laws. That's the second point. The third point is that the question of whether to grant a case management stay where there are pending criminal proceedings is decided by this court under the usual Reichholz grounds. So that is essentially that the stay is granted in rare and compelling circumstances. And there's a long line of English authority that we say it's applied equally here, which makes it clear that the burden is on the defendant to show that there should be a stay and that it's only granted in very unusual circumstances. And then my fourth point really is the policy behind that principle of stays being granted in rare and compelling circumstances. And that is that the reason why this court won't stay proceedings pending the outcome of a criminal investigation is because that criminal investigation has no, it does not result in some admissible evidence that this court can then take into account in reaching its own decision. It is your lordship who has the authority to decide the issues in this case, and your lordship won't delegate that authority to another entity to decide the point. And there's a long line of cases which I'm sure your lordship will be familiar with, starting with Hollington and Hewthorne, which say that the reports or decisions of other bodies are not admissible as the evidence of truth of their contents in this court. So even if the criminal case led to a criminal report, criminal investigation led to a criminal report, that wouldn't be admissible here. And even if the criminal report then led to a criminal case, which led to a criminal judgment, that criminal judgment wouldn't be admissible as evidence of the truth of its contents. It would only be admissible as evidence of the fact of a conviction, if one ever arose. But again, I can develop that point, and that these are all following well understood principles which are applied in this court and in the English courts. So with that introduction, my lord, if I may develop those points.
Yes, of course. Yeah.
So going to that first point, the operation of these particular laws, there are 2 laws that have been cited in the registry's correspondence. The first is, actually, I'll deal with the civil procedure point first. We've actually just uploaded this to case lines. Does your lordship have access to case lines?
Yes, I'll need to, if I get something, I need to reopen it.
Yeah, if you don't mind, my lord, I'm so sorry, but it was uploaded this morning in light of the late timing of all of this.
Well, what time was it uploaded?
I'm not quite sure, but shortly before the hearings, but it should be on the system.
What am I looking for?
So at the end of the bundle, there's section Q, which are the materials for this hearing.
Yeah.
And it's tab 80, which is entitled Federal. It's Criminal Procedure Code is what it's entitled.
Yeah.
Now I'm afraid actually this tab, the title for this tab is got jumbled with the next tab. So actually this tab is the Civil Procedure Law, and you can see that from the top of page 8141. And it's Article 102 that I just wanted to take you to. And if could your lordship just read 102 on page 8143.
Yeah.
So this is a power given to the civil courts, not this court, it's the UAE civil courts, to order a stay in certain circumstances. It's a discretion to order a stay, and it adds nothing, because although this particular power isn't given to this court, your lordship obviously has the power to order a case management stay. So I'm only showing you that to essentially exclude it from account, because it adds nothing to what your lordship would expect to have in determining this question. If we then go to the criminal code, which appears at tab 81.
Yeah.
Now this the relevant articles appear on page 8151 under Title 2. Does your lordship have that?
I will do in a second. Yep.
So this section of the criminal code deals with civil actions related to criminal actions.
Yeah.
And we'll start with Article 22. So Article 22 gives a civil right of action to a person who is the victim of crime. And it says, whoever sustained a direct personal prejudice from the crime is entitled to claim from the accused his civil rights during the gathering of evidence proceeding with the investigation or before the court examining the criminal case at any stage up to the close of all pleadings, but is not entitled to do so before the appellate court. So that gives a victim of crime a civil right of action which arises out of the crime, and you can see that from the title, which talks about the civil action related to the criminal action. And if that article, just understanding the nature of that cause of action, which is civil in nature, is relevant when we then come to Article 28, which deals with the point of stay. So perhaps your lordship could just read now 28.
Yeah. Mm-hmm. Yeah.
So there it was the civil case, and we would say that 22 is relevant to understanding what that means.
You say the civil case means what?
Well, I think we're saying that when you read the scheme of this, Article 22 gives right to a civil cause of action, and Article 28 then deals with the stay of that civil cause of action where there are concurrent criminal proceedings.
Right.
Now, for that, I'm providing that really by way of background, because the critical point for you today is in relation to the first paragraph of 28, that there needs to be a concurrent civil action and a criminal action.
Yes.
And in light of the helpful summary of the letter from the registrar, it's clear that there is an investigation, but not currently a criminal action.
Yeah.
So we say that we're not in the territory of 28. But even if we were, I would have submissions, which I'm not going to develop today, but I would have submissions on the nature of the civil case. It's not that any civil case, however remotely connected with a criminal case, would have to be stayed. it is I would need to develop that point because it's quite complicated, but there would need to be a high degree of overlap, commonality, etc. But for present purposes, the key point is there's no concurrent proceedings. So Article 28 is not engaged.
Yeah.
So those are my first points. My second point was that in any event, the Civil Procedure Code and the Criminal Code don't apply to this court. Now that point can be stated pretty shortly. The Civil Procedure Code is obviously dealing with matters of civil procedure. The Criminal Procedure Code and the passages I've shown you deal with a civil right of action. So although it's contained within the Criminal Code, it is effectively a civil piece. Now, in the creation of this court, the federal laws that created this court excluded the onshore civil and commercial law from the DIFC.
Yeah.
And the DIFC has its own, as your lordship knows, civil procedure and civil laws.
Yes.
And so it isn't possible on these matters of civil procedure to simply borrow from the UAE law. Your lordship is not bound by that. Your lordship is instead bound by our own civil procedure. Now that it maybe that's a point I didn't need to trouble your lordship with a great deal, but there have been a number of authorities on it. Perhaps I could just take your lordship to the IGPL case in the Court of Appeal, which is at tab 83 of the bundle.
Yeah.
And the relevant paragraphs are 83 to 88. Yes, my lord.
Page.
Page 8202.
Yeah.
So, and what those passages show is that, I mean, at 84, you can see this, that it formally excludes the federal civil and commercial laws.
Yes.
So this regime is a freestanding regime.
If all this case is going to show me is that civil and commercial laws of the DIFC are what one looks at and not of the onshore Dubai court, that's not a difficulty. But does it deal with the question of criminal proceedings being raised in Dubai?
No, it doesn't, my lord. But the point that I'm making, this is perhaps it's the key point, is that the matters that appear to be relied on by Mr. Al-Hashimi are matters of civil and commercial law of Dubai. Yes, of course, the context is.
You showed me the criminal code.
I did, but that section of the criminal code is dealing with the civil procedure. What is the civil procedure where there is a concurrent civil case and a criminal case? And that Article 28 power to stay. Sorry, my lord.
Is there any DIFC case that deals with the interrelationship between the DIFC civil and commercial code and the criminal code in onshore Dubai?
Well, not on this point, but
on any point.
Yes, so there are cases where this court has interpreted the penal code, and this court is empowered to do that. Right. And that happened in the TVM case, which is cited in Fidel and Felicia. But perhaps, my lord, we can just step back for a moment, because I fear that we're perhaps going too quickly on this point. Right. The passages relied on by Mr. Al-Hashimi are matters of UAE civil law. So they deal with the scenario where the civil courts will grant a stay of civil proceedings pending the outcome of criminal proceedings. Now, the key point there is that those matters, that stay that he's looking for, is a civil law question and a question of civil procedure. And that those civil powers are excluded in the creation of this court, because this court has its own civil procedure.
You say the powers are excluded, but the court has power to stay if it thinks it appropriate.
Absolutely.
So you say the powers are excluded.
The point that I'm developing is that if when your lordship is considering the stay question, your lordship is deciding that according to the usual common law principles, not according to Article 28. So
Right.
it would be an error of principle for your lordship to decide the stay question on Article 28.
Right.
Because that is not your lordship's authority. Your lordship's authority is your general power to order a case management stay. And it is true that this court has the power to order a case management stay pending criminal proceedings, but it does so under well accepted principles. And I'm going to show those to you. That's my third point.
Okay.
But I just wanted
Yep.
to
What do you take from IGPL?
I take from IGPL that the civil and commercial laws are excluded from the DIFC, and that includes the provisions that I've shown your lordship. So the Article 102 of the Civil Procedure Code, and also Article 28 of the Criminal Procedure Code. Now, I take the point that Article 28 is in the Criminal Code, but it is civil in nature because it deals with the conduct of civil proceedings.
All right. Yep. Okay.
My lord, unless I could develop that point about the exclusion of the.
No, you don't need to.
No, I mean, if there is quite a bit of authority on it, but it all really goes to the same point.
I think it's well established that the DIFC applies DIFC civil and commercial law and practice.
It is. It ought not to be controversial, that proposition. But it obviously depends. That submission for these purposes depends on that characterization question of the criminal code. So that's why it was important when I was showing you that section of the criminal code. It was important to take into account the heading of it and the scheme of it, all of which was dealing with the civil right of action, and then the case management powers for the civil proceedings. And so much like, I mean, there are the pieces of English legislation that spring to mind that have both criminal and civil elements. Of the Financial Services and Markets Act is one of them. You just have to look at the act. Some bits are criminal, some bits are civil. But we say on this point, it's plainly civil, and therefore is excluded from the DIFC.
Right.
So, my lord, having then explained why you don't have to be troubled by Article 28, I'll then introduce what your lordship's jurisdiction is under the usual case management principles. In the bundle, there should be, so I'm just looking for it, tab 87, the Snoras case. This is an English case, commercial court decision of Mrs. Justice Gloucester, as she then was. And the question in that case was very similar to the question in this case, whether there should be a stay of the civil proceedings pending criminal proceedings. Now, just to remind your lordship that often in cases of this nature, you're actually looking at a scenario where the defendant to the civil case is also a defendant to the criminal case. And that defendant says, understandably, I'm concerned that the civil case might require me to set out my defence, to give evidence, etc., and that may prejudice my position in the criminal case, and accordingly, the criminal case ought to go first. So that's the sort of classic scenario. And if your lordship goes to page 8322, there, Mrs. Justice Gloucester sets out there what we say is an uncontroversial list of the considerations this court will take into account in deciding whether to stay. The first is that, of course, you have the power, but it's a power to be exercised with great care and only where there is a real risk of serious prejudice that may lead to injustice. The second is the discretion has to be exercised by reference to the competing considerations between the parties. The court has to balance justice, and a claimant has a right to a civil claim decided, and the burden lies on the defendant to show why that right should be delayed. The third is that the defendant must point to a real and not merely notional risk of injustice. The fourth is the fact that a defendant has a right to remain silent in criminal proceedings and would, by serving a defence in the civil proceedings, be giving advance notice of his defence, carries little weight in the context for an application for a stay of civil proceedings. Obviously, that doesn't really arise here. And then the fifth point really goes to the same point, that even in criminal proceedings, you'd normally need to set out your defence. And then the sixth point's the same point, that actually positive defences tend to exculpate rather than incriminate. And then the seventh point again is about prejudice for the defendant. And then on the eighth point, a defendant thus has a choice between remaining silent in the civil proceedings or risk giving an indication of his defence, which may be used by the prosecuting authorities. Harshness of such choice does not provide a good ground for staying civil proceedings. And then finally, in the event the court were to be satisfied there'd be a real risk of serious prejudice leading to injustice if the civil proceedings continued, then the proceedings should nevertheless not be stayed if safeguards can be imposed. So pulling all of that together, Mr. Al-Hashmi bears the burden to show that there is a real risk of serious prejudice leading to injustice if these civil proceedings continue. And that we say that is the appropriate formulation where there are concurrent criminal proceedings. Here it's so much more difficult because there aren't actually concurrent criminal proceedings. There is merely a criminal investigation.
Mm-hmm.
And that really brings me on to my final point, which is the Hollington and Hewthorne point. So in some circumstances, the defendant will say, look, this is jolly unfair on me. There is complete overlap between the civil and criminal case. I must have an opportunity to fight the criminal case first. It's very resource intensive fighting two cases. It would prejudice my defence in criminal cases if I'm fighting a civil action. And accordingly, the civil case should await the outcome of the criminal case. We're not looking at that here. We're looking at something completely different. The way that Mr. Al-Hashmi put it effectively is that the criminal case might throw up something. It might throw up a point that might be relevant for this court in the determination of this case. And he talked about the findings in the criminal investigation. But those findings wouldn't be admissible as a matter of DIFC law in the adjudication that this court would have to come to. Now, it's also worth remembering that it's not yet clear who actually is being investigated in the criminal case, who the parties to criminal action would be. But there will not be complete commonality in the criminal proceedings to the parties in these civil proceedings. So by the nature of criminal proceedings, you won't have all of the interested people involved litigating in a way that would lead to a res judicata outcome that's binding on all the parties. The most you might result in is a conviction against somebody. Now, when one then looks at the English law and the admissibility, I mean, your lordship, I'm sure, would have looked at these many times, but the rule in Hollington and Hewthorne is well understood, sometimes criticised, but well understood. In tab 86, I've cited a recent authority of crypto open patent. I'd be grateful if your lordship could turn that up.
Mm-hmm.
Yep. Now, there are a line of Hollington or Hewthorne authorities. They're summarised in this authority at page 8292, para 35. I'm not going to take your lordship through all of those cases, but by way of reminder, there's Hollington and Hewthorne, then Land Securities of Westminster Council, City Council, then Secretary of State for Trade, Industry and Bairstow, and then Rogers and Hoyle. And Rogers and Hoyle is a Court of Appeal authority, and it actually summarises the principles quite neatly, and that appears at 8296. And if your lordship could kindly read paragraphs 41, and then the judgment of Lord Justice Christopher Clark at 42.
Yeah.
So the principle as a matter of English law is that the decision or reasoning of a third party body is not admissible before this court as evidence of the truth of its contents. So if the police investigation leads to an investigation report, that report would not be admissible as truth of its contents. And further, if the police then started criminal proceedings and the criminal proceedings resulted in a conviction with a judgment, that judgment would not be admissible as evidence of the truth of its contents. So none of that process would assist your lordship in the fact-finding task that this court is confronted with in these proceedings.
Mm-hmm. There is some authority, and it may only be in Scotland, I don't know, statutory authority to the effect, for example, that a conviction affects the burden of proof in the subsequent civil proceedings. Is there a similar thing in England? I know, because I had to deal with a case where the defendant in the case had been convicted of murder and was saying in a civil case that he didn't do it, and that the burden was on him to show that he didn't, rather than the ordinary civil burden on the other side to show that he did. It doesn't matter.
I'm not. It's an interesting point. I'm not familiar with that principle. I'm cautious about giving your lordship a statement on the law. Oh, here we go. My very efficient junior has said, if we look at paragraph 45 of the crypto case. Okay, here we go.
Right, that's the same sort of thing.
Brilliant.
Yeah. Yeah, well done.
Yeah, thanks to my learned junior on that.
One of the points you haven't touched on, I'm sure you're going to, is that as far as we know from what the police have told us, their investigation is prompted by someone representing the 6th, 7th, and 8th defendants, and not, and that's what they're investigating, the question of signing the guarantees by each of the individuals concerned as defendants 6 to 8. They don't appear to say that they're investigating the signing of anything else by any other party.
So I think your lordship is at an advantage on that, simply because your lordship has, I think, more information. I don't have that information, but there, I mean, I'd agree that there are likely to be very significant differences in the scope of the cases. I mean, I think it's worth remembering. I mean, one slightly loses sight of this with everything that's been said this morning, But there, in our case, there is no pleaded allegation that the bank acted dishonestly in relation to the entry of this transaction. I mean, the entire case, her defence, as we understand it, is that the defendants say they were defrauded by their own staff, unbeknownst to the bank. So the pleaded case, and it would be surprising if this was departed from, is that the bank entered the facility thinking it was a proper facility, lent and did advance the money bona fide in good faith. And indeed, the evidence is even after money was advanced the following year, Mr. Ahmed, who is the sixth defendant, was telling the bank that this money was going to be repaid and that they would honour the facility. So it's only subsequently, really at the start of these proceedings, that it was suggested that there had been some dishonesty on the defendant's staff, but again, not something that we were involved in. So whatever this criminal investigation looks at, I don't think it's being suggested, and I can be corrected if I'm wrong about this, that there was misconduct on the bank's part. But if there were, that would be a new allegation that wasn't actually an allegation in these proceedings. So again, it wouldn't be of interest to your lordship, because that's not a point being taken here.
Yeah, thank you.
Your Honour, I just would like to add something to Mr. Sharif.
In a moment,
representative.
Mr. Anoud,
Yes, sir.
If you just wait your turn.
Sure.
I'm still hearing Mr.
Thank you,
Shifty.
sir.
Yes.
So, but my lord, what I wanted to do just in my final remarks was pull to get, just to remind your lordship where we are in this case. This case has been going on a long time. This money has been outstanding since 2017. The proceedings have been on foot for more than 2 years. We have obtained disclosure, document production orders against the defendants, which they have repeatedly failed to comply with, and they are in serious breach of their obligations to this court.
It goes further. You've got judgment against all the defendants except the third defendant, well, and the second, but. Yeah,
that your lordship's absolutely right. I mean, that is a.
There's no continuing civil case against defendants 1, 4, 5, 6, 7, and 8. Is that right?
We've got judgment. That's a slightly complicated point. We've got judgment on our primary debt claims against those defendants. Yeah. There were some other causes of action which have been adjourned off. They are unlikely at this stage to be necessary because we have judgment.
I see. The case still continues in theory.
That the case would still continue, but it's adjourned with liberty to restore. Yeah. And it's not before you today. So that was one of the reasons why we were a little perplexed as to why Miss Al-Maraki is here. I'm not quite sure the capacity of which she's here. She seems to be making submissions on behalf of all the defendants, including the third defendant. And if she's making submissions on behalf of the third defendant, we don't quite understand her authority to do so. But in any event, the case against them is not before you today. The only issue today is the question of Delma Engineering's compliance with the existing court's orders. And we say we've established on the evidence that they have documents in their possession that are likely to be incriminating and undermine their defence, which they are not producing. And the only question is whether we should be allowed to take that forward and get another order to enforce compliance. And if they don't comply, for your lordship, then to consider sanction. So that is a context when you're looking at those principles from SNORAS, and which Mrs. Justice Gloucester set out there, and balancing the interests of the parties, you can, we say, put weight on the rather extreme position we find us. I mean, this is a defendant who has repeatedly failed to comply with the orders, and this latest letter from the police, which no one has explained the timing of this or how it came about and what Mr. Al-Hashmi's involvement of it was. But your lordship can put weight on the fact that this has happened at the last minute without any prior notice to us. without giving us a fair opportunity to understand what was going on. And that is very unattractive. And I'd also just remind your lordship that at the hearing on the 1st of March, Ms. Alanud made a stay application based on this criminal investigation. And she said she would provide the court with the details of the criminal investigation. And she plainly has the investigation number. And she didn't do that. And your lordship asked for that information, and she said it would be provided. So I'm afraid to say that we repeatedly see the defendants being secretive in terms of what's going on, and only giving information when they perceive there to be a tactical benefit. And that doesn't just go to costs, it actually goes to the fundamental fairness of these proceedings. And all of that, we can say, can be weighed in the balance. Now, my lord, I'm conscious I've taken you through quite a lot. Is there anything else that I can assist you on?
Not at the moment, thank you. I'm going to ask Ms. Al-Maraki first, and then I'll come back to you, Mr. Al-Hashmi.
Yes, sir.
Ms. Al-Maraki,
Yes,
your interest here is, what are you seeking? I mean, the application is made against the third defendant, Delma, and Mr. Al-Hashmi is representing Delma. You act, I think, for the 6th, 7th, and 8th defendants. But there's no application.
Correct,
there's no application today against you for anything.
Your Honor, first, Mr. Al-Hashmi was appointed by court in 2018, I believe so, or end of 2017. The case IDBI was in 2017, so before he was appointed. Our criminal case that we have applied in February, it's regarding the facility agreement, and that those agreements was not signed from my father, Mr. Ahmed Al-Maraki, and my sisters, Sharifa and Maryam.
Yeah.
The employees, the bank representatives, they have changed their statement twice regarding the meeting of Mr. Maryam. They have changed.
Ms. Al-Maraki, sorry, I don't want to cut you short, but what you're telling me seems to be the sort of thing that would be quite relevant to an argument at trial, if there was to be an argument about what happened precisely, who said what, and whether the bank had changed its case. But all we're concerned about at the moment is this application, which is for production of documents from the third defendant. I'm not understanding at the moment how the 6th, 7th, and 8th defendants who you act for, or who you speak for, how they are affected by this application.
Because one of the defendants, Maryam Al-Maraki, is related to Delma Engineer.
Yes.
And IDBI stated that Maryam has signed this facility in front of, in the present of the IDBI representative,
Yeah.
which they had not met her. They stated that they, yes, and it was before Mr. Al-Hashmi was appointed. And
yes.
the signature on the facility agreement is singly signed by Miss Maryam, where it should be duly signed by Maryam and her partner.
Ms. Al-Maraki, again, I'm sorry to interrupt. This application is not about who is right, who tells the truth, who does that. This application is about recovery of documents from the third defendant, who is present here today through Mr. Al-Hashmi. So I don't understand what your application or what you're submitting that is relevant to this application. Do you understand what I mean?
Sort of, Your Honor.
Well,
excuse me, my English is a bit poor, and
let me try.
I'm doing all my best to explain and to answer, Your Honor.
Okay, let me try and explain a bit more carefully.
Sure.
The the claimant in this case, Idbi Bank, has brought an action against 8 different defendants, all related in some way. Yeah.
Correct, Your Honor.
You act for, or you represent 6, 7, and 8. Yep.
Correct, Your Honor.
Mr. Al-Hashmi presently represents number 3.
Yes,
Yep.
Your Honor.
This application today is brought by the bank against defendant number 3, seeking an order for disclosure or production of documents by defendant number 3. Yeah.
Yes, Your Honor.
This application does not, the claimant in this application does not seek to recover anything from your people, 6, 7, and 8. They're not involved in this application by the bank. Do you understand that?
Yes, Your Honor.
So why are you, and indeed orders were made against 6, 7, and 8 back in March of this year, I think it was, which resulted in judgment on the main claims against 6, 7, and 8 being entered in favour of the bank. You're aware of that, are you? Hello, Mr. Al-Maraki. Mr. Al-Maraki. Mr. Al-Maraki. Ms. Al-Maraki. Ms. Al-Maraki. Ms. Al-Maraki. Shala, are you there?
Yes, Your Honor. What I'm gonna do is I'm gonna ask her. She just left the call, the
Could you?
hearing. I'll see if I can call her back in.
Thank you. We'll wait
Thank you.
until.
Your Honor, I'm unable to reach her. What I'm gonna do is I'm gonna try to call her into the hearing and see if that works, but she's not reachable.
Right, thank you. If you can try, but whatever method you think best.
I'm on it, Your Honor.
Your Honor, she's having some connection issues, but she's trying to log back in. She'll be here shortly, hopefully.
Right, thank you very much.
Thank you.
Hello.
Hello? Hello?
Hello.
Hello, is that Ms.
Yes.
Al-Maraki?
Speaking. Excuse me, Your Honor. It was disconnecting.
Are you? Can you show your screen? And can you show?
No, because I'm sorry, Your Honor. It's a phone call.
Oh, I see.
The meeting, yes, the meeting was disconnected. There's no connection, so I'm on the phone call.
Okay. Well, I think you heard until you suddenly disappeared. What I was saying was
Yes, Your
that
Honor.
so far as D6, 7, and 8 are concerned, that's your father and your two sisters, I think. They are not part of this application, and they have had judgment entered against them back in March for substantially the whole of the claim. So, what do you understand that?
Your Honor, all of the, it's all connected.
It may be all
Even
connected,
Delma
but
engineer is connected.
I'm asking you a different question. I'm asking you whether you understand that this application is only against D3, and that as far as D6, 7, and 8 are concerned, they are not part of this application, and judgment was entered against them for the very large part of the claim back in March, I think it was, of this year. Do you understand that?
Yes, Your Honor.
So, on what basis do you seek to intervene in this application?
To give us time, Your Honor, at least to appoint an attorney or a lawyer to represent, as far as Mr. Al-Hashmi is represented by Abu Dhabi court as a guardian, and he's representing Delma engineer. And Delma engineer is, my sister Mariam is one of the partners in Delma engineer.
But you can't represent Delma Engineering.
No, Your Honor, only my sisters and my father.
Yeah.
And sorry, it's only my sisters and my father. And that's Zafra Enterprises also.
Yeah. So there is no present application against your sisters and your father.
Okay.
So, it seems to me that you have no interest in this. You may have an interest, but you have no legal entitlement to speak on this application against D3.
Yes, Your Honor. Yes, Your Honor. I do
Thank
not have.
you very
You're
much.
welcome, Your Honor. You're welcome, Your Honor.
Thank you. Mr. Al-Hashmi.
Yes, Your Honor.
I'm sorry you've been left while we are discussing with other matters. Have you understood the submissions made by Mr. Shivji?
Yes.
Can you help me on this? I have no indication that a police file has been, a criminal case has been opened in Dubai in connection with this matter.
Yes,
And all we have is indication that the police are investigating.
Yes.
Particularly concerning the signatures obtained of D6, D7, and D8. That's Mr. Ahmed, Sharifa, and Miriam.
Yes.
But the investigation doesn't seem to have gone further than that. It doesn't seem to have led to a case being opened.
Yes.
And it doesn't seem to involve Delma Engineering, as opposed to the three individuals, father and two daughters.
Okay.
So,
Your Honor.
Yes, of course.
Yeah, let me explain the situation, because maybe in that time the Mariam was the partner of the Delma Engineering, and she signed this document that make the open criminal case in the police, and that's related to the case. One of the partner, before I appointed as a from the court, she opened the case related to Delma and the bank.
Yes.
On that fact, it's related to the request or the investigation in Dubai police related in somehow with the Delma Engineering.
But are you able to say that an actual criminal case has been opened, or is it still at the stage simply of investigation?
I am just a guardian appointment from the court. I don't able to make this statement.
You can't say, yeah. And my information from the information given by the police seems to be that their investigation concerns the D6, D7, and D8. That's Mariam, her sister, and her father.
Yes.
And the question of them signing a bank guarantee and bonds in their personal capacity, and nothing to do with the signature of anything by D3, that's Delma Engineering. So unless you want to say anything more, it seems to me that
let me explain with the point. Delma Engineering has a two partner, Mariam and Mr. Dulfaqar. The document that she asked about the sign related to Delma Engineering before I joined the Delma as a appointment from the Delma.
Yeah.
You get my point, Your Honor?
She was involved in signing, or should have been involved in signing the.
The case is related to signing the document related to Delma.
That's the case against Delma.
Yes.
But the investigation seems to be concerns the case against Ahmed, Sharifa, and Mariam. Person.
No, Ahmed and Sharifa is other party, not related to them.
Yeah. Well, is there anything else you want to say at this stage on the question of letting the application proceed? I am minded to continue, so I have decided that I should continue to hear the application today because in short, I'll say this for the record. There's nothing to suggest that a criminal case has been opened. It seems to be only at the stage of investigation so far.
Okay.
I'm not persuaded that the court is bound to stay proceedings, even if a criminal case had been opened. Article 28 of the Criminal Procedure Code appears to have in mind civil proceedings in Dubai, onshore Dubai, not the DIFC. Further, there does not appear to be any overlap on the information I presently have between the investigation on the one hand, which concerns the signing of guarantees and other documents by 6, 7, and 8, and the present application, which concerns Delma Engineering only. The application is only an application to seek an order requiring documentation from Delma Engineering, and it doesn't, at the moment, go further than that. It doesn't seek to investigate the merits of the case or to make any decision on liability. And so in those circumstances, it seems to me that there is no reason at present to stay the case or to stay the application, today's application, against Delma Engineering. So on that basis, I will allow Mr. Shivjay to continue and present his case. Now, are you content to stay and take part in the action, or what?
Your Honor, as I told you, I didn't have a money or fund to have an advocate or lawyer to present me as a Delma, and the Delma didn't have any fund. Why the reason why the IDB bank make the case against Delma, which is there's no fund, there's no money, and they always send me warning email about this.
Yeah. Mr. Hashmi, I can't make the decision for the bank. The bank have a right to bring a claim if they think it's justified. If they are going against Delma Engineering and Delma has no money, the bank may be wasting their time, but that is a matter for the bank, not for me.
Your Honor, be honest with me. They send me warning letter. They accuse me by myself. I didn't have any right to. I didn't sign this document, and I said I got several emails there. Excuse me. They will come against me personally.
Well,
how come?
I haven't seen that, and I can't comment on something I haven't seen. You'll have to take your own advice on that.
Okay.
Thank you. Well, Mr. Shivjay then will make the case for the order he seeks. Are you going to stay and take part in that discussion? Well, you're here for the moment, and so long as you're here, we will record it if you leave, but you can stay and listen. Mr. Shivjay.
I'm grateful, my lord. I'm also, we're grateful to Mr. Al Hashmi for being here, and certainly I think from our perspective we would encourage him to stay. I'd start by saying that this is a focused application against the third defendant only. It's not an application against Mr. Al Hashmi personally, but an application against the third defendant in order to discharge its current document production obligations to this court. And those obligations arise substantially out of an order that Justice Giles made last October, but also in relation to various promises and information that the defendants have provided since then. Now, throughout this litigation up to January, all of the defendants, the second defendant hasn't been participating is no longer a party. But all of the active defendants in this litigation were represented together by one firm. The evidence they filed collectively. The letters they sent, they dealt with collectively. And so there hasn't been at any stage in this litigation a relevant distinction to be drawn between their records and the information that they have to hand. And certainly the evidence that Mr. Al-Hashmi has given personally makes it clear that, like the other defendants, the third defendant has access to all of the records of Delma Engineering and the defendants generally, and that they're all stored in one or two locations in Abu Dhabi. Now, the purpose of this application, sorry, Mr. Al-Hashmi's gone off camera. Mr. Al-Hashmi, are you still there? Thank you. It may, subject to your lordship, it may be helpful, Mr. Al-Hashmi, just to stay on camera so that we can see that you're still there and we can make sure that you're following. So the purpose of this application is to enforce compliance with what the court has previously ordered, and also in relation to various defects in the information provided by the third defendant. This application very substantially tracks what was before your lordship on the 1st of March. It may be that we can shortcut matters somewhat, given that we have taken your lordship round this track once before. But in essence, your lordship has before you two witness statements: a witness statement of a third witness statement of Mr. Dylan Malone and a fourth witness statement of Mr. Dylan Malone. And they go through in some considerable detail the information that we have about the records available to the defendants, including the third defendant, and the inconsistencies and errors that they have put forward in their position over the recent months, and the areas where there are clear failures to comply with the court order, or areas where they've given information which we say must be wrong or is incomplete. Now, what we have done, as we did at the last hearing, is extract the defects that relate to the third defendant and put them in a schedule to the order. And yes, perhaps we can start there. The order.
Well, can we just find out whether Mr. Al-Hashmi has seen the proposed order? Mr. Al-Hashmi, have you received from the claimant bank a copy of their skeleton argument? You're muted. Mr. Al-Hashmi, you're muted.
Sorry, Your Honor. Actually, I get the connection directly between the Tamimi office and my email. I didn't get any document related directly from the bank, Idbi bank, which proving this agreement between Delma Engineering and the facility that claiming for.
Yeah, but did you receive their skeleton argument for this hearing?
Yes, for this hearing, yes.
And did you receive a draft order?
Yes.
The order they the court to make?
Yes, yes.
Do you oppose the court making that order, or do you agree to it but with certain changes you want, or what is your position?
My position, as I told you, I didn't have anything to object, because it's depend on the judgment procedure. I do my best to provide the proof or documents and so on.
Yeah.
And try to encourage the Marihi family to hiring the lawyer, or to fund to cover the lawyer cost for this hearing.
Okay.
But unfortunately, I didn't get any reply.
But you don't oppose in principle the order that they want the court to make, is that right?
Can this lady explain me, because it's a legal terms I didn't aware of it.
I'll try again. You've seen the draft of the order they want the court to make.
Yes.
And I think I understood from you that you don't oppose that in general terms. that
Yes,
right?
I didn't have, because I didn't have an advocate to make the reply.
But are there some parts of the order that you disagree with? You don't think the court should make?
The order itself, because the Delma is not involving, because the Delma is they don't have anything to cover the whatever the order from the judgment came. And
Okay.
the previous judgment in March, it's mentioned the partner, the related party, which is Mr. Al-Muriqi family and the other company.
Yeah. Well, Mr. Shivji, I think I'm not sure what the position is on the draft order.
I'm grateful, my lord. Shall we proceed? I mean, at any point, if Mr. Al-Hashmi has observations to make or concerns, we'd obviously welcome them. I mean, I'll come back to this point later, but it's regrettable, but we've had no engagement from Mr. Al-Hashmi in the run-up to this hearing. And in fact, the last substantive communication we had from him was a message saying that he wasn't going to respond to our correspondence, and that in fact we ought not to write to him again, and that if we I think there was a threat to refer the matter to the police. So that it is somewhat unhelpful, because our position is that this hearing could have been avoided and that these issues should be agreed. It does seem to us that if Mr. Al-Hashimi is right and that Delma Engineering is not currently in funds, then it's not likely to comply with this order. And we'll have to be back here again at another expensive hearing, leading to yet more expense incurred for my client. But I'll come to that when we look at the mechanics of the order, because it may be that we can try and design it in a way that saves costs. The order Your Honour will find, so Your Lordship will find at tab 79.
Is this page 81332?
Yes, it is.
Yeah.
And this follows the scheme of your 1st of March,
Yeah.
which went on the 2nd of March. So we've essentially modelled it.
Let me just see whether Mr. Al-Hashmi has this on the screen. Do you have this order on the screen before you?
Can 1 second, let me open the. Your Honor, I got now the draft of order, which 8 pages. Yes.
Yes, 8 pages. Yeah.
Yeah.
Yeah. Have you read it, or
Yes.
have you read it?
Yes.
Right. Well, if you listen to Mr. Shivji as we go through it, he will.
Okay.
If you indicate if there's something you have a problem with.
Yes.
Okay.
Yes. Let me explain you, Your Honor, about something. I am from the court, from Abu Dhabi Civil Court, and it's be responsible for me if I agree what Mr. Shivji said. They sent me the email that must I accept to add Delma Engineering for this case. If I say yes, I have maybe legal responsibility against local law. Maybe the partner came later to me, why you involve Delma without any proofing because it's been my statement. They come back to me by civil case or local law for this statement. That's why I didn't reply to Mr. Shivji and not agree about this point, because somehow it's again it can open legal case for within local law.
Yes, I see. Thank you very much.
Mm.
I think that's clear, Mr. Shivji, that I think that's an explanation for the lack of contact beforehand, that he's concerned that in the local law, a case will be made against him for agreeing to something which he shouldn't have done.
I mean, that's an argument for another day, but he's an independent office holder.
I'm only trying to summarize the explanation.
Yes, well, we've heard that, and if it won't be an issue today, but it may be an issue on another occasion. And all I would say is that the office holder principles in Abu Dhabi are no different to any other jurisdiction in the world. And as an office holder, he has to deal with the affairs of the business responsibly. And I will show you that correspondence later, because Mr. Al-Hashmi's position actually is extremely unhelpful, and he's threatened to refer us to the police.
Let's get on with the order.
I am grateful, my lord. So, so the paragraph 1 of the order relates to the internal investigation documents. The defendants had promised to give this at the hearing before Mr. Justice Giles, and it was recorded in the recital to the order. They still haven't been given. So it seems to us that there can't be any objection to an order confirming that.
I think somewhat unusually. I'm going to, as we go paragraph by paragraph, I'm going to get Mr. Al-Hashmi comments. It's difficult for a non-trial lawyer to keep all points in mind. Mr. Al-Hashmi, we're dealing with paragraph 1 of the order. It's, I think, of the draft order. It's concerning the internal investigation into the affairs of the Delma companies. And I think I'm right in saying that there's already been an order that you should give those documents. And this is repeating that order, in effect. Yeah. Is there anything particular you want to say about this? I'm not asking you to agree to it or anything, but
yes, they ask about they sent me a mail that must agree about to add Delma engineering in the case. When I agree, when I say my statement to agree, based on my agreement, the owner of the company or Delma engineering or any third party can come civil case against me with the local law. How can?
So, Haji, sorry, it's my fault in not explaining properly what I'm asking you. What I'm saying is, I'm assuming that you won't formally agree to this order.
Yes.
I understand that.
Yeah.
For reasons which you've explained.
Yes.
Whether they're good reasons or bad reasons, I'm not going to rule today. But I understand that you won't want to give. We can't say this is an order with your agreement. But in terms of any positive argument you want to make, is there anything you want to say about paragraph 1 of the order? Or do you, it follows from an earlier order, I think, is that right? That you give documents relating to the internal investigation. And what they're seeking in this order is to get those documents by 4 p.m. on 13th of July. That's 2 weeks. 10 days time? No, but a week's time. It's a week's time. So that's what they're. Is there anything particular you want to say about this paragraph of the order?
No. No, because to reply about the statement, I must have a lawyer. Unfortunately, I didn't have a lawyer to make to reply.
On the last occasion, back in March, you said I think you were going to get a lawyer, or you had a lawyer.
I tried the best to find a lawyer, but unfortunately, I didn't found lawyer with the Muriqi family promised to fund the company to have a lawyer, but that not happened.
Okay.
That's why I promise you that the first time that I will bring the lawyer based on the promise from the Muriqi family to fund the company to cover the cost of the lawyer.
Okay.
That's why today I cannot mention this.
Okay. All right. You haven't got a lawyer, but you are you are a court-appointed official and you understand what paragraph 1 is asking for, is there any reason why you can't give that document, give that production?
Okay. When you know, they talk about the Delma engineering, there is no headquarter. As I mentioned before, there's no headquarter and there's no proper document. What I mentioned, there's small stuff and there's no document that I provide. When I came to Delma engineering to 2018, I didn't find the headquarter. I didn't find the documents. I didn't find anything. How can they know about the storage, this document? When I first came to the Delma, I make inventory counting and check that. I didn't find this document. They asked about something, actually I didn't have. You get my point, Your Honor?
I think so, yes.
I'm serious.
Sorry, my picked up one of those automated things. Right, Mr. Shifty, what you're seeking at the moment is the order. If the explanation given, there being no documents, is really one that comes to the next stage if the order is not complied with, I suppose.
Well, that's right. Actually, sorry, I think Mr. Hashmi, if you could put yourself on mute for a moment, then there won't be an echo. I think it's just worth remembering that the defendants themselves promised to give these documents, and they themselves have referred to the internal investigation. So, and I'm afraid to say that Mr. Al-Hashmi's submissions he's made a moment ago about the records are not consistent with his own evidence about the records kept by Delma Engineering. So that's not an issue that your Lordship can resolve today. This is something that they promised to give in the October order and was recorded in a recital. It's something that your Lordship ordered the other defendants to provide in these terms in the order of the 2nd of March, paragraph 5, and we're asking for the same order against the third defendant to do.
Yeah. Very well. Then, Mr. Al-Hashmi, I'm going to make the order in terms of that paragraph, and you should comply with it. If you can't comply with it, you ought to set out in detail in a statement what efforts you have made. Right? Do you understand?
Okay. Let me explain you. Okay. Let me explain. The first time I joined Delma, appointed from the court to Delma, I didn't found proper storage of the documentation, and there's no documents. What I got it from the Delma management, previous management, tools and stuff and items which I mentioned in my report, and I shared this report to Tamimi firm. What they asked the document, there's no document. There's no headquarter currently for Delma. There's no store. What they have only the view items which already counted, and I share it with the Tamimi family. Tamimi family. They know about it.
Well, that is for another day, I think. Okay, Mr. Shifty.
Yes, I would agree. I mean, all I'll say is that Mr. Al-Hashmi has filed sworn evidence about Delma Engineering's records. And they show that there are documents. So the submission that there are no documents is not correct. But I think we will move on. If need be, I'll take use of that evidence. But today it's just about getting the order, and then it may be that progressively we'll need to come back on compliance.
Right. Paragraph 2.
Paragraph 2. So again, this follows the order that we obtained against the other defendants in your 2nd of March order. This is enforcing compliance with the October order. They were required to provide certain information. In Schedule A to the order, we've set out the defects of the information that is missing. It really covers the full range of things that they were ordered to do. So the electronic data repositories, domain names, hard copy files, professional advisors, present location of data and lost data. These are all areas where we can show that Delma Engineering had access to this information. So that these records ought to exist. They appear, one derives from Mr. Al-Hashimi's affidavit that they do exist, but these are gaps in what we've been told. So, and we've explained in our skeleton argument and in the evidence why this is information that they ought to have available to them. There was one other point, which is that Mr. Al-Hashimi's affidavit was unsatisfactory in that it looked like sections of it had been cut and pasted from the Al-Maraki's own evidence. And there was one part of his affidavit where he refers to the table of cases in my sister's affidavit. Now that language has been lifted probably from Mariam's affidavit, possibly Sharifa's affidavit. But neither Sharifa or Mariam are Mr. Al-Hashimi's sister, as we understand it.
And I've got that point.
Yeah, and that was an affidavit. We do have some concerns that Mr. Al-Hashimi is just not taking this process seriously enough. But I'm just putting that on the record because this time he's being ordered to go away and do it again. And I would encourage him to take this seriously because it costs, ultimately, it's a matter of compliance with the court's orders, but it costs us money if he doesn't.
Mr. Al-Hashimi, paragraph 2 of the order that's sought. Do you understand what it requires?
Yes, Your Honor. What I mentioned before, there's the documents and the document they want, it's out of my hand. When I came to Delma, I am only myself. They assume there's a staff there. They have a finance department, IT department to make eligible for providing this document by the code. Actually, there's no staff. All of the labor all of the staff open labor case against in the court against Delma. So they asked the document, and I didn't have any staff. I didn't have this document. How can I provide the document to them?
But would it help if I dealt with that point?
Yes. What I think, yeah, okay.
I think because we could understand if we were making an order that was impossible for Delma Engineering to comply with. We can understand if that was a concern of your lordship, and we're not asking you to do that. We're asking you to provide the information that one can draw from Mr. Al-Hashimi's evidence and other documents must exist. So if your lordship goes to part F of the bundle and tab 79,
F79.
yes, please, and that's page 935.
Do you have this, Mr. Al-Hashimi?
This is Mr. Al-Hashimi's own affidavit.
F79, do you say?
Yes, tab 79, page 935 is the start of the affidavit.
Do you have that, Mr. Al-Hashimi?
Currently, didn't have it with me.
Do you have the court, what's it called, case management file?
Only I have the draft of order, and that's what I have.
Okay. Well, if Mr. Shivji will then take you to the relevant part and read it to you.
I will do. Thank you, my lord.
This is your affidavit, Mr. Al-Hashmi, sworn on when?
It was sworn on the 9th of November 2021.
Do you understand that?
Okay.
And Mr. Al-Hashmi, it's clear from the end of the affidavit that you gave an oath when approving this document, and that oath was given by video conference to Mr. Federigoli. Do you recall that?
Yes, sir. I didn't remember that time, but can you share me this?
I don't. I'm on a. You're stretching my technological abilities, I'm afraid.
Okay.
If I know that my team from Al Tamimi are on this call, if someone from Al Tamimi could send over Mr. Al Hashmi's affidavit, I know my junior is also on this call, so my junior could just make sure that document is downloaded from case lines and sent over to Tamimi, and if Tamimi could email it straight over to Mr. Al Hashmi. Mr. Al Hashmi, do you have access to your email at the moment?
Yes, I have it. Yes.
Okay, well, we will send, if subject to the judge's view, if I may,
Yes.
I'll read out the passages whilst that process is happening in the background, and hopefully by the time I finish doing that, the document would have arrived and you can have a look at it.
Right.
So, Mr. Al Hashmi, this document is the evidence filed by Delma Engineering pursuant to Justice Giles's order, and it says, paragraph 5, the offices of Delma Engineering were in the Al Musafa Industrial Area, Abu Dhabi. In January 2016, those offices were closed, and the remaining 12 or 13 employees were moved to the Al Nair office, taking a limited number of equipment and devices with them. The company's archives and hard copy files were relocated to a storage facility in the Al Mafraq industrial area. During 2017 and 2018, all the remaining employees of Delma Engineering gradually left, and then you go on to say that you were appointed judicial guardian in late 2018.
Yes.
And then in paragraph 18 of your statement, actually I'll pick up at 17, you say that when Delma Engineering ceased its operations in 2016 and its Al Musaf industrial area offices were closed and vacated, there were no human resources available to secure, organise, categorise the remaining archives of hard copy files. All the employees from the audit and accounting departments left Delma Engineering in 2017 to 2018. To the best of my understanding, the company's remaining hard copy files are now located in the Al Mafraq site and a small store under the office building in Al Nair. That material consists of voluminous documentation related to the construction, engineering and procurement projects Delma Engineering was involved in. And then you go on in your evidence to explain that those files have mixed up, and you go on to say that in your view, it'd be impossible for you to organise them. Now, I take the court to that evidence to show that it is clear that those files exist at this present moment in time.
Before I came, but yes, it exists before I came that time.
And Mr. Al Hashmi, if you may, let me just finish my submission, and then
okay, sorry,
the judge can decide when you respond. This evidence undermines the point that Mr. Al Hashmi's just made, that there are no documents. It is plain that there are very extensive records. The point that was being made was a different one, which is that the documents were not easy to review because they're disorganized. But even that evidence should be treated with some significant skepticism, because the affidavit of Ahmed, which was filed on behalf of Delma Engineering in September, and presumably was filed with Mr. Al Hashmi's authority, said there that a manual review had been conducted of the hard copy documents, and essentially the evidence was that all responsive documents had been identified. So the evidence has changed from originally we have reviewed our hard copy documents and identified responsive documents to evidence that in fact the hard copy documents were in a jumble and impossible to review, to evidence today that there are no documents. And in that context, we would say it is appropriate for the court to make this order, because all we're seeking are essentially explanations about documents that have previously been admitted to be in the defendant's possession. I'm sorry, my lord, I believe you're on mute.
Do you understand that, Mr. Al-Hashmi?
Your Honor, the situation is very clear to me. When I came, it's the same. What the statement I mentioned, the document is not organized and we miss it, and there is no staff can help me or to find this document.
Right. Well, I think what we're going to have to do, I see no basis, on the basis of the previous material, it seems to me that the claimant must be entitled to the order it seeks, and you must answer it as best you can. And if you'll see that paragraph 2 requires an affidavit from you explaining why you failed to comply with the terms of the October order and addressing the defects identified in the schedule to the order. Now, whether you have documents or don't have documents, that is an opportunity to explain why, explain what the position is. And I think it's important that I see no reason not to make that order and require you to comply with it. Do you understand?
Okay, understood, yes.
So I'll make that paragraph of the order. What about paragraph 3?
So paragraph 3 is a narrower category of documents. So under the DIFC rules, much like the English Civil Procedure rules, where a document is mentioned in a statement of case, there is a right on the other party to inspect the document. In Sharifa's evidence, which is adopted by Mr. Al-Hashimi in his evidence, she lists the other civil cases. I'm pausing for a moment. I believe that they're mainly civil cases. They may not all be civil cases, but the other cases that the Al-Marakis have been involved in. And they say that these cases are evidence of the fraud that they were allegedly subject to by their employees. That we are entitled to inspect those documents under the rules. They haven't been provided. And so we ask for an order for that. Again, this replicates the order that your lordship made on the 2nd of March.
Yeah. Any particular observation about that, Mr.
No, nothing.
Okay.
The next one is a very granular point, but one of the factual points in issue is the attendance of particular individuals at a particular office over a particular period, and there is an attendance book for that office which exists, again, which we say we have a right to inspect. We've only been allowed to look at one page for one date, and we haven't been able to look at either side of the page. And what actually matters is attendance over that period. So,
who controls it?
It was in the control of the defendants, as we understood it.
Which defendant
had all of them. They acted collectively, and as we understood it, the third defendant had a right to access it, and we certainly inspected it pursuant to that right previously. So again, we would say that we should see that.
Mr. Al-Hashmi, any objection to that?
No. But
I should say that if for some if I make the order and you say you can't provide the document, you must explain why you can't provide it. Do you understand?
yes, understood. But as I told you, there's what the document they asked for is out my hand. I cannot found it because not.
Then that is what you must say in an affidavit.
That's it.
So if they ask me about the, 1 second. Your Honor, you heard me?
Yes. Yeah.
If they ask me about the document and they repeated about the document and the document that I didn't have because the situation of the company was not renewed the license from 2016. I came after 2 years later, which is in 2018, and didn't find anything. I didn't find the stuff. I didn't find the proper document. So how can they ask me about the detail about the document that didn't have it? I didn't have the proper stuff that can help me to found it.
Okay. Well, I think again, I'll just emphasize that I see no reason based on previous material not to make the order. I will make the order, but if you say you can't comply with it, then you must say so precisely and clearly on affidavit.
Okay.
Do you understand?
Okay, I mentioned because Your Honor, you must understand. You're supposed to understand my legal situation and my lack of legal procedure in the DIFC.
Yeah.
Didn't have anything about the RFC requirement, DIFC. That and what are they?
If I make the order, you must comply with it. And if you find you cannot comply with any particular part of it, you must say so and explain why clearly and in detail, so that your explanation can be investigated. Do you understand?
Okay, yes, sir.
Okay, so I'm minded to make the orders in 3 and 4. The documents in Schedule B.
Yes, my lord. So again, this follows the same scheme that we took in relation to the other defendants. So
This is paragraph. Mr. This is paragraph 5.
Okay.
That's right.
Okay.
So what Mr. Dylan Malone's evidence in his 3rd and 4th statements does is a careful, precise and forensic analysis of the materials that have been provided to date to identify where the gaps are. And we have been very careful to make sure that where we have sought further information, it is reasonable and proportionate in the context of this case. We're fully aware that lawyers can sometimes get a bit carried away and ask for too much, and we've been very cautious not to ask for anything that is more than is absolutely necessary to decide the issues that are relevant in this action. And what we've done is focused on the gaps that are clear from the defendant's own evidence. And the explanation of this is set out in a lot of detail in Mr. Dylan Malone's evidence. But these are essentially bullet points, again, which I said track the scheme of the 2nd of March order in identifying where the deficiencies are.
Yeah. Okay, Mr. Al-Hashmi. Again, your answer presumably is the same, that you don't have any documents. But I think that's not a reason not to make the order. And if that is your answer, well, in answer to the order, then you must explain why and try and answer the questions in Schedule B in as much detail as possible. You understand?
Okay.
Yeah. Paragraph 6.
So my lord, this I think it's worth pausing just to discuss this paragraph in a bit more detail. The last hearing, the hearing on the 1st of March, I had a discussion with your lordship about sanctions for non-compliance, and yes. I think, paraphrasing, as I understood it, your lordship was concerned was that if the order specified now the sanction for non-compliance, there might be confusion later as to whether or not there'd been compliance, and as a result, whether the sanction applied. And on that basis, what your lordship did is make an order essentially summarising what the consequences would be, but saying that the question of compliance would come back before the court for you to determine 3 weeks later.
Yeah.
And in fact, in the event, actually, there was no compliance whatsoever, and no one turned up to that subsequent hearing. Yeah. So your lordship then entered judgment. I mean, I'm not going to press the point in light of what you previously said about prescribing the sanction in advance. What we're proposing here is exactly the same language that the 2nd of March order had, and it would work in the same way. There is, being honest, there is a reluctance on our part to have to schedule another hearing and the expense of that, simply because of the fact that I understand that. I thought your lordship would say that, but I thought it would flag. I would flag that. I mean, I'll float the other permutations and see if they're of any interest to your lordship. But I mean, the main one would be whether, rather than having to come back, we could deal with this on paper. But I'm conscious, as against that if we're in a world where there's simply no compliance whatsoever, then it is simple. But if we're in a world where there is some compliance, then I can see that a paper-based process becomes somewhat unsatisfactory, and in fact might take longer to sort out than simply having a hearing where your lordship can have all the information to hand. So we are in your hands on this. I mean, I think the sort of fundamental point from our side is that we really need to move this case on. It is taking a long time.
You have to be realistic. I don't know whether Mr. Al-Hashmi is correct or not in saying he doesn't have any documents. That's not for me to decide now. But if he doesn't, or if you're not going to get them, you may want to think whether this process is helping you. So it's not for your view or anything. But
no, well, I understand.
For example, Mr. Al-Hashmi may come back with an affidavit saying, I can't give X, Y, and Z because of certain reasons. In one sense, that is a failure to comply with the order. In another sense, it explains why he can't comply. And probably in those circumstances, if the excuse was credible, would probably result in the case not being struck out, the defendants not being struck out. One would just have to address each question on its merits and whether the issue justifies the expense that involves. Is a matter for you to have in mind. But so what I would be inclined to do would be to say, and we had little discussion on the second occasion in 22nd of March, whatever, about the word shall after third defendant's defence. And I would propose to say may be struck out, and that then fits more consistently with the following sentence.
Yes, well, I'm in light of your lordship's previous observations on that, we would be content with that. Can I
get rid of the square brackets?
So we'll get rid of the square brackets. We will need to find a date for that hearing. We would be keen to. I mean, it's subject to your lordship's diary, obviously, but we would be keen to do that as soon as possible, because for fear of this drifting longer.
Right.
And that's paragraph 7 of the order.
What's 3 weeks from today? Today's the
6th.
6th, 3, 7, 21, 27th. Can't do that. What about the 22nd? That's two and a bit weeks. Or else, as you know, better to have today's the 6th, you say? Yeah.
Would the 25th be a possibility?
Yeah, I'm tied up. I'm tied up all that week. I could do something like the 2nd of August or the 3rd of August. Oh, no, I can't actually. Sorry. I could do the 22nd of July, but that's quite tight for if there's going to be compliance.
Well, I think our preference would be to go with that date, because I think so, because I think otherwise there's a risk that this will just drift. Can I say something about perhaps with trespassing on your lordship's patience? Would it be possible to hold that date if we get a volume of material from Mr. Hashmi on the 20th and it just looks like the hearing is not sustainable? Then we may have to write to the court to ask it to reschedule. Is that acceptable, or would that cause your lordship difficulties?
I don't know whether it causes me difficulties. It may cause the court administration difficulties. Shah, are you there?
Yes, Your Honor.
Did you hear what Mr. Shivjay was suggesting, that we fix a hearing, or we didn't fix a hearing, but we schedule a hearing for the 22nd of July on the basis that it can be got rid of, use a formal expression, if it's not necessary.
It's up to you, Your Honor. It's I'll be more than happy to cancel the hearing if needed, and I'll be more than happy to list it and continue and proceed with it if needed as well.
Okay, why don't we fix the hearing? Sorry, I haven't asked Mr. Al-Haji yet. What is suggested, Mr. Al-Haji, is that
will be tight because Your Honor, during this week it will be our festival Eid. So
Eid this week.
This week, the whole week, start from Friday till Monday.
Right.
So it would be too tight for me to make any.
Yeah, I understand
holiday. Yeah.
Sorry, actually, I'm so sorry, but our understanding is that Eid runs from this weekend to next week.
Yes.
So could you just confirm the dates, Mr. Hashmi, of Eid?
Yes, it's start from this Friday, from 8th to 11th. All the public holiday, yeah. From 8th to 11th.
Would that prevent you producing material by the?
No, how can it be? Because the time would be too tight to me, because this period is a public holiday, is everything closed.
Yeah, that would then give you from the 12th to the 20th. That's 8 days.
Yes, it's too tight to me to prepare the reply.
If it's going to be an effective exercise, that you need to give time to comply with it.
Yes.
The problem is I'm not available after that until about the 15th of August or 16th of August.
Okay. Okay.
So sorry to negotiate diaries, my lord, but I'm away that week of the 15th of August, but I'm back at the beginning of the week of the 22nd. Does your lordship have any availability in those days, 22nd, 23rd, 24th?
Yes, I could do the. I think I could do the 22nd.
And Mr. Hashmi, is that possible for you?
It's tight to me. Tight to me to prepare the documents and prepare a professional to make the reply and provide the documents to reply. This week.
Hang on. We're talking about 22nd August, not July.
August, okay. August, okay. Yes, okay.
That's Monday, 22nd August.
Okay.
And if we say that you produce the documents by Wednesday, the 17th of August, that will give you time.
Okay.
Is that right?
Okay.
Mr. Shifty.
No, well, I think no. I'm afraid, if I may, I'll push back on that, because we will need a chance to review those materials, and we may want to file evidence in response. So, I mean, the order envisaged the scheme of a couple of weeks, but I mean, this is an order from October of last year, and this unless order application has been issued since December. Mr. Hashmi's had 7 months to comply with it already.
Well, this is an order, though, that you say is to have consequences. Therefore, it's important Mr. Al-Hashmi has enough time to do it properly. And
Yes.
what about Mr. Al-Hashmi? If we gave you until the 10th of August to answer the.
Okay. Let's make it to 15th of August and let him to reply.
But well, let's make it 10th of August because.
Okay.
10th of August,
Okay.
it gives the claimant then time to decide whether to go ahead with the hearing on the 22nd.
Okay. Okay.
All right, so what we'll say in the order is we've already, hang on, we need to go through timing with, back to paragraph 1. Do you need separate dates for these compliance, Mr. Suchi?
They don't have to be separate dates. I mean, I would just press your lordship not to be too generous with Mr. Hashmi. I mean, if we give him to the 10th of August, that's another month from now.
Yes, there seems to me that therefore there should be no excuse for non-compliance.
Well, I fear, though, that that's exactly where we'll end up, and then we will need to file evidence in response on whether the excuses given are good enough.
You'll still have a week and a bit.
Well, I appreciate that, but your lordship can see from the weighted material that we've put in that this is often a sophisticated forensic exercise, which involves going back to what was previously said and comparing it to what is now said to identify the inconsistencies. So, I mean, I in my submission, 10th of August is still pretty tight. I mean, if we gave Mr. Al-Hashmi till the end of July, then that would at least give us enough time to go through what is said very carefully. If there are additional documents given, we can go through those, and that would just make the hearing more useful for your lordship.
Your Honor, I think the 10th of August is reasonable and make time to me to make the reply for this case.
I don't like negotiating in a hearing, but what about the previous week, Mr. Al-Hashmi? The 3rd of August.
Pardon?
3rd of August.
No, it's good for me. 10th of August.
No, but
10th of August, I will do the best to try to finish it.
Mr. Al-Hashmi, 10th of August doesn't give the claimant very long to decide whether to proceed with the hearing on the 22nd of August or to put in evidence. What about the 3rd of August? That gives you a month from now. 4 weeks from today.
But you know, the next week is almost public holiday, and I cannot find the attorney to make the reply. I must back because I have a lack of DIFC law and procedure. I must back to advocate who has a specialist, and he can help me to make the reply and provide the documents, supporting documents.
We're going to cut through this. I'm going to stick to 10th of August for compliance. Okay. But I will. What about instead of the 22nd? Would you prefer to have a couple of days later, Mr. Shivji, to give you a bit more time? 25th?
Yes. I can't do the 25th. I could do the 24th.
24th then. 24th August, Mr. Al-Hashmi.
Okay. Okay.
10th and 24th.
Okay.
Let's go back to the order. Do you need a different in paragraph 1? Should that be 10th August? Is there any
I mean, on those, this is a body of documents that they themselves have referred to that they agreed to give in October, and when it comes, we'll need to go through it. So I think my submission would be they ought to be provided earlier because it will take us time to review.
I think we just discussed that, haven't we?
Okay.
I think we should set a date that is achievable, so that there can't be any excuse thereafter that there haven't been time to do things.
Mm.
On that basis, I think we should fix 10th August, unless there's any particular reason for staggering them. 10th August for the paragraph 1. 10th August for paragraph 2. There's no particular reason to have them separate, is there?
No, that's fine.
10th August for paragraph 3.
Yes.
10th August for paragraph 4.
Yes.
10th August for paragraph 5.
Yes.
Paragraph 6, well, the word will be may be struck out,
Yes. We've got that.
and delete the square brackets. Paragraph 7.
So paragraph 7 will be the 24th of August,
Oh. And it will state at the end, so further hearing, there should be a further hearing on 24th August at 9 UK time, 12 Gulf time, with a time estimate of 3 hours. The hearing may be discharged on a written application by the claimant. If Mr. Al-Hashmi, what I'm saying there is that
Yes.
the hearing will be fixed for 24th August, but if the claimant does not want to proceed with the hearing,
Okay.
it is sufficient to write to the court, copy to you, and then the hearing will be discharged. Is that okay?
Okay.
And then the question of costs. What I'm minded to do is deal with the costs. Is to deal with the costs by to be determined on the next occasion. Mr. Shivji, do you object to that? Probably.
I do, my lord. I would encourage you, if we just step back for a moment, look at where the bulk of the costs of today have gone. The bulk of the time was spent on an unsuccessful application for a stay of the proceedings. I think it's important. I think your lordship does need to see the correspondence running up to this hearing, because there is now a repeated pattern for hearings where your lordship gives directions for the preparation of the hearing, including skeleton arguments, which the claimant complies with to the letter, which the defendants don't comply with at all. Right. And then at the hearing, we're sprung with a last-minute application. And for today's hearing, the first we heard of this application was late last night when we were contacted by the registry. My team have been working over.
I think it's the first Mr. Al-Hashmi heard of it.
I don't believe that's the case. Mr. Al-Hashmi can tell us about when he first became aware of the criminal case.
Mr. Al-Hashmi, when did you first become aware of the police investigation?
I think during the case, it's during March 2000. Yes.
I see.
And
very well.
My lord, perhaps can I just develop that point, because I think it is an important point. It's important this parties litigating before this court respect this court's directions. And if I could just show you a couple of points in the correspondence. We'll go to bundle Q, tab 40. Tab 40, page 7645.
Yeah.
And this was essentially a pre-application letter that we sent ahead of revival of this application,
Yeah.
explaining quite clearly and fairly what we were proposing to do, and asking Mr. Al-Hashmi whether he intended to oppose the application, and if so, on what basis. And when your lordship's finished looking at that, that was exactly the sort of letter the court would expect us to send before doing this. Yeah. And then if you look at Mr. Al-Hashmi's response at tab 41, page 7647.
Yes.
Grateful if you could read that in the middle of the page.
Right.
So the essence of it was, I mean, a full-throated defence to everything that was being said, saying that he reserved his rights to defend the company that I represent by all means of proof and defences. So no, not giving up any ground at all, saying that everything would be fought. Yeah. Now, so as a result of that, we then contacted the court to revive this application. Yes. And there was a long tangle with listing, because the court asked for the parties' dates of availability. On each occasion, Mr. Al-Hashmi said that he was only available for the very final date in the window, and that was unsatisfactory. And I don't need to take you to all the correspondence and listing, but it tells you, we say, quite a lot about how this case is being litigated. Tab 57, tab 56, 7761. Yeah. And I'd be grateful if your lordship could read that.
This is from your side?
This is from our side to the registry. So the listing discussion started in May, and as you know, we've only managed to get this hearing now listed for July. But if you could just have a look at the history of listing.
Yeah, right.
So I'm putting it bluntly, we say there was a messing around on listing, and Hashmi was not being frank about his availability. And then we continue. Anyway, the court went on then to list this hearing. Court with the usual directions as to skeletons. Mr. Al-Hashmi didn't comply with any of that, and indeed didn't correspond with us. And the final contact was contact summarised in a letter at tab 72. Where we had a telephone call, some of my solicitors had a telephone call with Mr. Al-Hashmi's legal representative on the 12th of May. And in that call, his representative said that our firm, Al-Tamimi, should no longer contact Mr. Al-Hashmi directly. If the bank required anything from Mr. Al-Hashmi, it should make its request directly to the competent court. And that the bank should not make any, in inverted commas, further threats against Mr. Al-Hashmi, failing which his legal representative would file a complaint with the police. And so we were told not to communicate directly with Mr. Al-Hashmi, but in circumstances where there was no other contact on the record, there was no other person that we could send the correspondence relating to this hearing to. So we sent him the skeleton and we sent him the draft order. Mr. Al-Hashmi didn't file any documents with the court, didn't give the court notice of these criminal proceedings. And your lordship will recall back at the 1st of March hearing that your lordship said then that the information about if there was a criminal investigation, it should be provided. And he sat on that information. And then the first we learned of it was last night. And then since last night, my team have been up, I'm not complaining, but my team were up late last night researching all these points. They were new points to us, and up again this morning. It costs money. It does take time, and your lordship expected rightly me to be on top of this material. But last night I was a stranger to it, and that is why the cost has gone in preparing for today. It's taken by far the largest amount of time in preparation, and also at this hearing. And it was an application that was unsuccessful. And given Mr. Hashmi's conduct in the run-up to this hearing, not giving notice of the application, not corresponding with us, taking a fairly hostile and uncooperative approach on listing, this again is a classic scenario for indemnity costs. The cost we're looking for is against Delma Engineering. The order that we seek today is against Delma Engineering, not against Mr. Al-Hashmi personally. And the cost order is against Delma Engineering. But it's important that this court polices compliance with its rules and fair dealing between the parties. And when that doesn't happen, this court must react. So in our submission, it is a classic case for indemnity costs. And I ask you to make an order accordingly. We filed a statement of costs. The costs actually are, in my submission, really modest for the amount of work that's been done. But we'll come to that in a moment, perhaps.
I can't find your statement of costs. Where is it?
Tab 77.
I've looked at it, but I could. Yeah. Yes. Yeah.
But one final word, my lord, which is that the circumstances on the 1st of March were nearly identical. Your Miss Alanu turned up. She made an application for a stay based on the criminal proceedings. The time was spent on that application, and your lordship then did order that those defendants paid the costs on the indemnity basis. So yes. in our submission, for exactly the same reasons, that the context is depressingly, disturbingly similar to how that hearing came about, and for those reasons, we would ask for a cost on the indemnity basis.
Assessed in that amount.
Assessed in that amount, yes, please.
Before we deal with the question of costs, can I just once or twice in your substance of your order, I said to Mr. Al-Hashmi, if he can't comply with a particular paragraph, he must say so on affidavit. Say why, give an affidavit explaining why he can't comply. Does that need to be put into the order, or is that implicit?
I think it would be helpful. Perhaps I could just say a few words about compliance, because your lordship actually went a bit further and suggested that there were some excuses that might be offered which would be good excuses. And although that's for another day, I think it's very important that we're clear on what this scheme is doing. The order is against Delma Engineering only. There is. Yeah. I act for office holders very regularly. I fully accept that there are circumstances where, when office holders personally are in a difficult position, may not be in funds, they may have other professional commitments. The question of compliance will be whether Delma Engineering has complied and has a good excuse. The fact that Mr. Al-Hashmi may not have staff, may not have easy way of going through the records, is irrelevant for those purposes. They're a good excuse for why Mr. Al-Hashmi can't do it, but they're not a good excuse for why Delma Engineering, which is the party that's choosing to run this defence, hasn't produced the documents that it has to under a court order. So in our submission, there are actually no good excuses that Delma Engineering can come up with. And because these issues go to the fairness of their defence and the fairness of the trial, their non-compliance, we would say, would render these proceedings unfair from an Article 6 perspective. So I don't object to Mr. Al-Hashmi putting in an affidavit explaining the circumstances, but that isn't going to deal with the fundamental fair trial point that I will make about Delma Engineering. And your lordship may take the view that we simply make the order, and it's a matter for Delma Engineering to decide what, if anything, it says. But if it doesn't come up with a satisfactory compliance with the order or an answer to the order, that your lordship then may well impose a sanction at that point. And that may actually be fair on Mr. Al-Hashmi, because his position is probably likely to be, I'm an office holder, I'm not in funds, this involves a lot of work, and I'm not prepared to do it at my own expense. And that would be, I'm not going into his obligations as an office holder, but one at a personal level might feel some sympathy with Al-Hashmi, Mr. Al-Hashmi, but of course it would be absolutely no answer for Delma Engineering, and in those circumstances your lordship could enter judgment against it. And in my submission, that is probably the direction we're headed at. So I'm not going to press the point about whether Mr. Al-Hashmi wants to put evidence in, because he's heard from your lordship that if Delma Engineering doesn't comply with this order and Delma Engineering doesn't come up with a satisfactory explanation, then your lordship will take what action that your lordship considers necessary.
Right. Where does that leave the question of whether to put a reference to an affidavit, reference to an affidavit in paragraph 1, for example? Or,
well, in my submission, it wouldn't be necessary, because the court has ordered that these documents should be produced, and and Delma Engineering to date, over the last 7 months, its application hasn't actually come up with a good reason why that order should not be made. If it later wants to try and excuse its non-compliance, that is a matter for it. But I don't want to suggest in this order that would be good enough, because my submission is it wouldn't be. So
we'll leave it out. Mr. Al-Hashmi, that discussion was about compliance or non-compliance, and whether there should be an affidavit in the event that documents ordered to be given cannot be given by Delmar Engineering. You've understood, I think, when I've told you as we've gone through it, that if production cannot be given, the explanation as to why it cannot be given should be part of your affidavit. So I don't think it needs to be spelled out in the order, but it's clear that it is relevant, for example, to the question of sanction if documents are not produced that should have been produced. Okay. Now, what about costs? What the claimant is asking for is the costs of this application on what's called an indemnity basis. That's full costs, and they've put a schedule of costs in, which I think you've seen.
Yes.
Of 187,000 dirhams.
Okay.
That is dirhams, isn't it?
Yes.
Do you say anything about whether Delmar Engineering should pay the cost of this application? And secondly, do you say anything about the application for costs on that basis or in that amount?
As I mentioned before, there is no fund or money to cover this cost, and this over maybe it's made by the firm, which they may raise the fees and double the fees and the hour. So how can the Delma cover this cost? Cannot cover this cost.
So are you saying Delmar Engineering cannot cover these costs? No, or
cannot cover this cost at all?
Well, that is
they know about.
That is a matter for enforcement or not enforcement in due course. Is there any reason why I shouldn't make the order for costs? And they have made an application. They've come to court in the absence of any satisfactory offer to produce the documents. They've come to court. They have had to spend a lot of time dealing with the application to stay the case based on the criminal investigation and so on. Is there any reason why, having been successful, they should not recover their costs? Leave aside whether Delmar Engineering can pay the costs. That's a different matter. Is there any,
Actually, the cost is overrated. It's double the market. How can they make this cost 170,000? Too much.
have you got the cost schedule in front of you?
Yes.
What particular figures do you want to?
Because they add all the stuff, and it's unreasonable to add this stuff.
So which part is unreasonable?
Let me open the.
Yes, of course.
Yes. Maybe they add 4 person.
Yes.
And this Patrick they didn't contact at all with me. How can they add it? And you will see the time is become too high for this case. The hour and the rate.
So time and rate.
Yes.
This, in fact, it doesn't cover the work done over the last day or so when faced with the police investigation and having to make preparation for the argument on that.
Yes.
Mrs. Shivji, do you want to say anything about hours and rates?
These are our standard rates. I mean, with the greatest respect to Mr. Al-Hashmi, the preparation of application like this takes a lot of work. Your lordship can see we put a long skeleton in. It isn't even a matter of lifting the previous work. One has to actually look at it carefully to make sure that it remains accurate. It's all the more burdensome when you're dealing with a litigant in person, because we obviously go to double our efforts to make sure that everything was presented fairly and completely. I'm acting for a leading firm of solicitors here who are meticulous in their record keeping. So this is a reliable record of the work that was done. The rates are market rates. I hope your lordship gets the sense, just looking at the bundle update alone, of the enormous amount of work of preparing an application for this properly. Now, Mr. Al-Hashmi's side, he's not represented, so he hasn't complied with the court's direction. So he's not really in the best position to judge how much work it is because they didn't do it. But in our submission, this works out at less than $50,000, about £40,000. Given the time we've spent, the number of people, the fact there's leading counsel involved, we would say that's a very reasonable amount.
And you said there's quite a lot of last-minute costs incurred, which haven't featured, obviously, for those reasons. That's right. They are to be, as it were, swept up in whatever order I make.
Yes, I mean they are. I mean that is against
my
client, but we are where we are. I think so. Yes, Mr. Al-Hashmi gets the benefit of the fact that we've done a lot of work in the last 24 hours that's not captured here. And if you make a cost order today, he doesn't have to bear another cost schedule dealing with that.
Yeah. Well, I'm persuaded that it is appropriate to deal with costs today. The claimant should have its costs of the application today. I think it's right, given the background, that they should be on the indemnity basis, and I will assess the costs in the sum of 187,109 dirhams. And leaving out just to be clear, that is payable by the company. I know you say it has no money. It's not an order against you personally. It's an order against the company.
Okay.
Very well. So that's the order. Is there any other question on the order? Perhaps you can prepare it with the registry in terms of what has been decided. Sharla, are you there still? Can you liaise with the claimant about the precise terms of the order? We went through it in detail, but just to make sure that the order reflects the decisions made during the course of this morning.
Certainly.
Thank you very much. Right. Well, we'll maybe see you on the 24th of August. Thank you very much. Thank you both.
My Lord, there is just one final point, which is I showed you the letter where Mr. Al-Hashemi's representative said that we should not contact him directly anymore. He is the only person on the record. So I just wanted to be clear that we feel that we have no choice but to continue correspondingly directly with him until the point that he appoints a representative who takes over on the record. The threats that were made included a threat to refer us to the police. I mean, we're stuck between a rock and a hard place on this. If we continue to have conduct of the matter, we have to correspond in this way. So I'm just raising that now. It may well be that Mr. Al-Hashmi wants to address the court on the right way forward, and the court can hear that. But at the moment, we consider ourselves stuck in a position where we have to correspond with him directly, whether we like it or not.
Mr. Al-Hashmi.
Yes, I get several email from the Al-Tamimi firm that they will come to myself personally. They are treating me. They told me, if you not do this, we will come suit the case against you personally. I have several email mention word personally and come yourself personally. Then why Mr. Sharif said they didn't do anything? If I am from the court and I am the third party and not responsible for this company, how can they send me several email? That's not one email that in case you don't do this, I will come to you personally. Mr. Sharif, can you reply for this email that your firm sent it to me?
Mrs. Sharif, since you've raised this question.
So, so I think Mr. Al-Hashmi might be getting slightly confused.
Not, it's clearly mentioned, Mr. Sharif. Sorry for interrupting.
So, Mr. Al-Hashmi is currently on the record for the third defendant, and he has provided his email address as the address for service. So we are obliged to correspond with him through that means. We have said and maintain that we will reserve our position on third-party costs against him. We've not gone further than that, but we have a potential entitlement, and all we're doing at the moment is reserving our position. Now, I get the sense from what Mr. Al-Hashmi has said that he feels that that's rather inflammatory. It's not intended to be inflammatory. I understand why that may be a concern to him, but that's not something that's being pressed at the moment. And insofar as it's a distraction, I would encourage Mr. Al-Hashmi not to be distracted by it. The aim of this application and the return date is to deal with Delma engineering. So if that is an area of sensitivity, perhaps Mr. Al-Hashmi can just remember that all that's happened is that we've reserved our position as we're entitled to, but we are obliged to continue corresponding with him as the address on the record. So I hope that makes that point clear.
Mr. Al-Hashmi, it seems to me that the claimant solicitors they have to correspond with you because there is no one else acting for the company. So if that is understood, they can continue to, until there is a lawyer representing the company, until there is a lawyer, then you are the person that they have to send things to. And so I think I'd leave it on that basis that you must expect that when they correspond in connection with this case, it will be you they correspond with unless and until a lawyer is appointed to represent the company.
Okay.
Thank you both very much. We'll see you later in August, maybe. Thank you.
Thank you, Your Honor.
Thank you.
Thank you.
Thank you.